Thank you, Mr. Chairman. Congratulations to the nominees. Thank you all for being here. I want to start with you, Mr. Trung, Ms. Suttonberg, and Mr. Ricard. You've all been nominated. So they put you all right together, right in the middle. You've been nominated to the D.C. Superior Court. I just want to ask you a question or two about your judicial philosophy, and I want to start by referencing a picture that maybe will come up behind me. This was maybe a photo you've seen before. It's not a pleasant one, but it did occur right here in the district. This is Edward Correstein. Edward was 19 years old when this photo was taken. This is just from July of this year. He was a government employee at the time. This is in Logan Circle here in the district. He was out one evening, I think with his girlfriend, when he was attacked. He and his female friend both were attacked by a roving band of teenagers who left him in this condition, beat him pretty badly, as you can see. He was able to get his female friend into the car and safe, and then turned and confronted the whole band of them himself. And this is the condition he was left in. Looks pretty violent to me, but when the assailants were taken before the D.C. Superior Court, the relevant judge, Judge Kendra Briggs, who I'm sad to say was reported favorably out of this committee, though, over my no vote, she gave the assailants 0 prison time.
Hello, everyone. Welcome back to the channel. If you're new here, I'm your independent political analyst, no spin, no tribal loyalty, just facts, context, and balanced commentary. Today, we're diving into a Senate Judiciary Committee exchange that highlights one of the most important and controversial questions in criminal justice. What is the real purpose of sentencing? Is it punishment, rehabilitation, or something in between?
Prison time. 0 prison time. And what she said was the purpose of sentencing is not punishment. That's a quote, not punishment. It is rehabilitation. And apparently she thinks that allowing people who do that kind of thing to 19-year-olds, allowing them to get off without any kind of punishment is rehabilitative. That is its own interesting question. But I want to ask you first, do you agree that the purpose of sentencing is not punishment, but rehabilitation? I'd like to hear from each of you on this. I think it's an important question. Mr. Trung, let's start with you.
Thank you, Senator. My approach to sentencing is to consider the pre-sentencing report of the defendants, the witness victim impact statement, the community impact statement, any recommendations from the prosecutors and the...
But what's the purpose of sentencing in your words? What's your philosophy?
My approach to sentencing is to consider all the facts, apply the law, and to impose sentence that reflects the seriousness of the crimes.
Well, do you think that punishment is an appropriate aspect of sentencing?
That is one factor to consider within the context of the approach to sentencing.
Do you agree with Judge Biggs that the purpose of sentencing is not punishment but rehabilitation?
Your Honor, Senator, I don't have...
That's fine. You can say Your Honor. It's all right. I'll answer that.
I appear in court so many times that I have the reflex of referring to those in the honorific title. Well, Senator, I don't have all the information that Judge Briggs had in front of her. So and I need to be circumspect in my response because judicial canons counsel that as a judicial nominee, I should refrain from commenting issues that may appear before me.
Well, I'm not asking you to comment on this case. This case is over. You're not going to have this case. I'm asking you about you, and I'm not asking you about her. I'm asking you about you. I want to know what your judicial philosophy is. And my question is, would you agree that the purpose of sentencing is not punishment, but rehabilitation? That's a pretty stark, that framing is pretty stark. Not punishment, but rehabilitation. Do you think that's right?
Well, my sentencing philosophy is to impose a sentence that reflects the seriousness of the crimes and the imposed consequences that are deserved within the context of studying the facts and applying the law to the facts.
Okay, I wish you'd be a little less circumspect. Ms. Suttonberg, go ahead.
Senator, I can't speak to that particular case given that, but I will say that I spent my career as a prosecutor fighting crime, and I'm certainly committed to ensuring accountability structures and judge both for juveniles and for adults. When it comes to sentencing, I think that there are important retribution, deterrence, incapacitation, rehabilitation. Given the severity of the crime, I think you have to look to what is going to serve the interest of justice in any particular case, and there could be different goals that are depending on the
Let me ask you this. Shouldn't keeping the public safe be a major goal of sentencing?
Yes.
Shouldn't keeping violent offenders off of our streets be a goal of sentencing?
I absolutely agree. There should be.
Okay, good. Mr. Ricard, what about you?
Yes, Senator, thank you. I would follow the law of the District of Columbia, which requires considering a number of factors, including the seriousness of the offense, imposing a sentence that reflects the seriousness of the offense and the criminal history of the offender, a sentence that provides sufficient deterrence, both specific deterrence to the individual offender and general deterrence to the community, and that the third factor does consider rehabilitation, but that's just one of the three factors that has to be considered.
And last question, Mr. Chairman. And do you agree that protecting the public and getting violent offenders off the streets is an important goal of sentencing?
Yes, I think that's the deterrence that I just mentioned. Specific deterrence is making sure that someone who's committed a violent crime and is likely to do so again would not do so.
Well, I'll have some more questions for those of the rest of you on the panel. I'm sure you're very disappointed I didn't get to ask you any. Congratulations again on your nomination.
Thank you. We've had some discussion, about the necessity for independence.
Change centers on three nominees to the D.C. Superior Court, Mr. Trung, Ms. Suttonberg, and Mr. Ricard, during their confirmation hearing. A senator known for his tough-on-crime stance used a recent and tragic case to frame his questioning. He referenced the story of Edward Korstian, a 19-year-old D.C. resident who was brutally attacked in Logan Circle earlier this year. According to the senator, the attackers received no prison time from the judge handling the case, who reportedly said that the purpose of sentencing is not punishment, but rehabilitation. That statement sparked outrage and became the senator's central focus. His line of questioning wasn't just about the nominees, it was about whether America's justice system has tilted too far toward leniency. This is where things get interesting. When asked directly whether they agreed that sentencing should be only about rehabilitation, all three nominees gave careful, cautious answers, as you'd expect from judicial candidates. Mr. Trung emphasized the importance of applying the law to the facts and issuing sentences that reflect the seriousness of the crime, but he avoided a direct yes or no answer on whether punishment should be central. Ms. Suttonberg, on the other hand, offered a more well-rounded response. She acknowledged multiple goals of sentencing retribution, deterrence, incapacitation, and rehabilitation, and agreed that keeping the public safe must always be a priority. Mr. Ricard took a legalistic approach, citing D.C. law, which requires balancing seriousness, deterrence, and rehabilitation. He made it clear that rehabilitation is only one factor among several. So, what we saw here was a trio of nominees try to walk a fine line, acknowledging complexity of sentencing while avoiding political landmines. This exchange captures a much deeper philosophical divide in the American justice system. On one side, there's a belief that punishment and deterrence are essential, that accountability and consequences maintain public safety and social order. On the other, there's a growing movement emphasizing rehabilitation, arguing that reducing recidivism and addressing root causes can be more effective than purely punitive measures. The senator's frustration wasn't just about one case. It was about a broader concern that some judges may be prioritizing compassion over consequences. But at the same time, the nominee's caution shows an awareness that rigidly focusing on punishment doesn't always lead to better outcomes. The truth probably lies somewhere in between. A fair justice system must both hold people accountable and create paths for redemption. From a neutral standpoint, this hearing wasn't just about judicial philosophy, it was about how we define justice itself. There's a valid argument that rehabilitation without accountability can undermine public trust, especially when violent crimes go seemingly unpunished. But it's equally true that punishment without rehabilitation fails to address why crimes happen in the first place and can perpetuate cycles of violence. What's clear is that sentencing must balance justice for victims, safety for communities, and fairness for defendants. None of these values should cancel the others out. As for nominees, their restrained answers might frustrate some viewers, but that restraint is, in many ways, what judicial temperament looks like: careful, deliberate, and guided by law rather than politics. So, what do you think? Should rehabilitation ever take precedence over punishment? Or is the senator right that some judges are going too soft on crime? Let me know your thoughts in the comments below. If you found this breakdown helpful, make sure to like, subscribe, and hit the bell for more analysis that cuts through the noise. No partisanship, just perspective. Thanks for watching. I'll see you in the next one.